All right, and I think we can get started. And again, good afternoon, everyone, or depending on your location, good morning. We are ready to get started with the ABCs of BOPs and PBMs, a comprehensive guide for pharmacies. So first of all, thank you so much for taking the time to attend this webinar today. Harini and I are looking forward to presenting on this. Just a couple of reminders. I want to let you know that we have the Q&A function enabled at the bottom of your screen, so please feel free to take advantage of that during the webinar. Note that the chat function is disabled, so only Harini and I will see any questions that you pose. So please feel free to ask any question that you have. Any that are generally applicable, we'll try to address during the webinar. With that said, we'll dig right in and I'll hand it off to Harini.
Thanks, Lucas. Just really quickly, I think we just wanted to mention that the webinar is being recorded. So you should be able to receive a copy of the link to the recording after this discussion here today. And as Lucas mentioned, feel free to use the chat feature. Definitely ask any questions that you might have during the presentation itself.
And then as we go forward, one final reminder, we always say with our disclaimers, since we are a law firm presenting on this, this is not intended to be legal advice. This is meant to be a general overview of some generally applicable principles, but we do encourage you all to reach out for any further questions or clarification you have after the webinar. As we go forward, just a little bit of background about Frier Levitt. I'm sure some of you may have attended prior webinars, but Frier Levitt is a boutique healthcare and life sciences law firm, and we focus exclusively on issues related to healthcare and life sciences. So in that capacity, we work with a wide variety of different providers throughout the entire country. We are based out of the New York, New Jersey area, but we have the capability to work with providers in pretty much any location.
My name is Harini Bupathi. I'm a partner here at Frier Levitt. I work in the life sciences practice group, primarily the payer side as it relates to life sciences. Most of my focus relates to helping different types of dispensing providers, such as pharmacies, retail, mail, specialty, as well as dispensing physician providers on a range of PBM related matters, such as audits, network access issues, terminations, fraud, waste, and abuse investigations, et cetera, to be able to counsel these types of practices and pharmacies to be able to avoid any adverse actions from payers, PBMs, as well as state boards of pharmacies.
And just a brief background about myself. I'm also a partner here at the law firm, and I work alongside Harini a lot of times dealing with PBM issues. Harini will often work in areas involving active ongoing investigations or audits of pharmacies and other PBM related issues, because to be clear, there are more than just audits and investigations out there. There's credentialing, contract review issues, those sorts of things. But every now and then a matter does transition from something that transitions into either litigation or arbitration, depending on the circumstances. And that's where I will often step in. So I've had the honor and privilege of representing a wide variety of providers in litigation and arbitration throughout the country, in other what we'd call quasi-litigation settings as well. On top of that, I also do a lot of work with boards of pharmacy and other healthcare related administrative agencies throughout the country. So I'm not quite at 50 yet, but I'm getting close to being able to say that I've handled matters in almost all 50 states throughout the country in some capacity related to boards of pharmacy. So that's just a little bit about my background.
And that's really interesting, Lucas, it's not interesting, but it's just obviously very common that we start off with our introductions, especially you on the BOP side and myself on the PBM side. And we've done a bunch of these presentations, especially myself presenting on PBM audits and network access issues and terminations, and you doing a whole series on board of pharmacy actions. And it made sense for us to kind of combine our expertise in both of these areas to be able to understand really the relationship that pharmacies have with both the boards of pharmacies as well as their PBMs, and the dynamics between maintaining those relationships and having an amicable relationship between both of them. And to that point, one of the things that we'll be doing in this discussion is to understand those relationships that pharmacies have, both with boards of pharmacies and the PBMs, and how they intersect, as well as any sort of mutual reporting obligations and the importance of communication with both your boards of pharmacy and your PBMs alike.
And that's such a good point, Harini. I appreciate you mentioning that, because so often, to Harini's point, we talk about these as two separate things, And I think the more and more Harini and I have worked together, as well as with our colleagues here at Frier Levitt, we've just seen more and more overlap, interplay in relationships between PBMs and boards of pharmacy. So I also want to touch on this idea of treating BOP matters with due regard. One of the things that I've kind of observed over the last several years is that given the essential aspect of PBM relationships, the fact that I've often said, including in court, that although at times a pharmacy's relationship with a PBM can be hostile and adversarial, depending on the circumstances, it is essential. In many ways, it's a lifeblood of a pharmacy's ability to operate. But so is the relationship with the Board of Pharmacy. You must be licensed as a pharmacy to be able to do business in your state. And I would also say that you must be in good standing with your Board of Pharmacy to be in every major PBM network, but you also need to be in good standing with PBMs, and that also relates to your standing with BOPs. And then I think we're going to conclude with this notion of building amicable relationships. And I just kind of want to preview that this does not come from a place of being naive. I just said that sometimes this relationship can be adversarial, but how do we try to improve that relationship and build a foundation that allows for there to be amicable discussions and trying to find a middle ground that's going to help you have a more positive relationship with these essential entities. Now, when we talk about the interplay between these two entities, we want to talk about this notion of communications. PBMs communicating with boards of pharmacy, but also boards of pharmacy communicating with PBMs. And so we definitely do see different areas and methods by which these entities communicate with one another. Some of those are direct, good old-fashioned communication. It might be email, it might be phone calls, it might be in-person meetings. But in other ways, it's less direct communication, but it's still communication nonetheless. If you look at PBM credentialing applications or forms, or the re-credentialing applications, almost every PBM is going to inquire about a pharmacy standing with its board of pharmacy. It might be the pharmacy's home state, but it might also be any other state in which the pharmacy is licensed in. Now, if you're a pharmacy that's licensed in one state and one state only, this is probably going to be a little easier to kind of keep tabs on, so to speak. But if you're a pharmacy that does business in multiple states, we see this a lot in the area where our firm is based in New Jersey. We see a lot of pharmacies that might be licensed to do business in New Jersey, New York, Pennsylvania, and the list goes on and on. So the more licenses that you maintain, the more important it's going to be to make sure that you're keeping a close eye on your standing with the BOPs. But PBMs are absolutely going to inquire about this. But the same is true with boards of pharmacy as it relates to relationships with PBMs. Boards of pharmacy will at one point or another inquire about standing with the major payers. And to be clear, payers can cover a lot of different entities. It could be an insurance company in a direct relationship with a pharmacy. It could also be a state or federal government agency, CMS, a Medicare agency, a Medicaid agency based at the state level. But it typically is going to be one of the major PBMs. And we know that we currently operate in a highly consolidated PBM marketplace, 3 PBMs covering about 80% of the marketplace, and from there, another about 6 covering 95% of the marketplace. So what are BOPs going to ask in these types of situations? Well, during a renewal of a license, or if you're seeking new licensure for a new pharmacy that you're opening, something like that, they may ask whether you as an individual pharmacist or as a pharmacy owner have had any prior issues with a payer within the last X number of years, for example, within the last 1 year, 2 years, 5 years. Have any payers terminated their relationship with you? If so, what was the basis for that termination of that relationship? So they're going to ask these questions. And what I would say is they're essentially communicating with one another through, at minimum, their applications for licensing or credentialing. Because if these things are reported accurately, then they will be able to learn more about them and they may inquire further.
And that brings us to the point of what PBMs look for, as Lucas mentioned, when pharmacies seek application into their networks. One of the most important considerations when starting a new pharmacy or acquiring a new pharmacy is to be able to get a state board of pharmacy license, without which you wouldn't be able to operate a pharmacy, nor would you be able to get access into a PBM network. The process and timeline, obviously, to be able to get a board of pharmacy license can vary based on state by state. It's generally a questionnaire requesting information and documentation related to your pharmacy, as well as its operations, often followed up by an on-site visit. And the reason that we include this point here is most often folks forget about a timeline when starting a pharmacy, and that before they can get in the door and start processing claims and servicing their patients, they need that board of pharmacy license, among other things, of course, to be able to consider applying for a PBM contract. And so often complying with Board of Pharmacy rules and regulations demonstrate that a provider can meet the technical terms of a PBM credentialing network, such as labeling, signage, prescription filling, et cetera. And to that end, it's important for pharmacies to consider that licensure that you obtain through the Board of Pharmacy could also affect your ability to contract into a particular PBM network. For example, Lucas just mentioned that when PBMs often ask about licensure at the time of credentialing, including not just your state Board of Pharmacy license, but also any other licenses that you maintain as a non-resident license holder in any other state. And that might also become a question of curiosity for many PBMs. For example, if you're a retail pharmacy seeking access into a retail pharmacy network in a PBM, what you might have non-resident state licenses in other states if you intend to do mail order, or if you're designated as a mail order with your state board of pharmacy and you have a mail order pharmacy license. Those are all questions that PBMs could typically ask and are often notorious in asking to make sure that the licensure type or the license of the pharmacy aligns with the access that they're also seeking as a pharmacy as well. So it can certainly affect the type of credentialing process that a pharmacy is required to go through in a PBM network, or require additional explanation for the pharmacy when trying to get into the network as well. To that extent, there's also many questions on PBM credentialing applications that inquire about a pharmacy's standing with the Board of Pharmacy. This could extend to not just the pharmacy, but also to any of its employees. That could be a pharmacist, it could be a pharmacist in charge, a pharmacy technician, or any licensee holder. And oftentimes in these applications, a simple yes or no might just be concerning to PBMs. And so often it's very important for pharmacies to consider expanding on their responses to be able to provide additional explanation as to why an answer might be yes or an answer might be no, especially if the answer kind of errs in that gray area of having to provide a response to a PBM. Some example questions could be simple as, is your license in good standing? Within the past X amount of years, has the pharmacy had any issues with the Board of Pharmacy? This could be something as simple as just probation, or disciplinary action, including a monetary fine, any past or failed inspections. And again, this could also extend not just for the pharmacy, but as well as the pharmacist, the pharm techs, and any other licensee holder at the pharmacy. In fact, most PBM applications ask expressly, has the pharmacy, any of its employees, ever had any issues with the State Board of Pharmacy or any other regulatory agency in the past 6 years? So those are very typical questions that pharmacies should expect when seeking application into any network. And to that extent, there's also the expectation, and we'll go into this in a little bit, of being able to report any of these disciplinary actions that pharmacies face through the course of their participation in their PBM networks. But as a threshold matter, just to be able to get into the door, it's very important for pharmacies to be transparent. The other more obvious reason is because PBMs are easily able to go to State Board of Pharmacy websites, be able to look up your licenses, whether you're a pharmacy or you're a licensee holder, and see if there's been any actions against the pharmacy. So in those instances, it's very important for you to be proactive in making those disclosures, especially when the information's already publicly available and easily attainable by any PBM that looks you up.
Harini, one of the points you had made was the idea, if you have a question that may be phrased as just a simple yes or no answer, the idea of providing some additional information at a very basic level. Can you just tell us a little bit about what that looks like?
Yeah, so for example, if one of the questions is, have any of your employees ever been faced with disciplinary action? The answer might be yes, because of your pharmacist's previous employment at another pharmacy, for example. That has nothing to do with your pharmacy and its operations, but that pharmacist might have had disciplinary action or was placed on probation during the course of their employment at another pharmacy. And that explanation and that clarification would be very helpful in providing to a PBM to distinguish that any disciplinary action that might have originated with that employee at another place of employment is separate and apart from the employee's role and their operations at this pharmacy. And so that type of explanation could certainly help distinguish why this pharmacy that's seeking admission into the PBM's network is otherwise in good standing, that their employees are otherwise in good standing, and that any sort of past disciplinary action shouldn't extend over to this pharmacy's request for participation. And if you were to just provide a yes answer, I can't say that it would necessarily be helpful for the pharmacy. And so in those instances, being able to provide that clarification without just worrying about what the PBM might interpret that disciplinary action to be could be very helpful in you providing that proactive disclosure, because PBMs could, take a very take a board of pharmacy order that they might see and misinterpret it completely than perhaps what the circumstances were. So if you are able to disclose it, and if you're able to provide an explanation, you are controlling the narrative there.
And then just kind of shifting into the idea, Harini really just spoke about PBM inquiries on BOP actions or other government actions, shifting to BOP inquiries on other BOP or PBM actions. So we already talked about this notion of boards of pharmacy asking about a pharmacy's participation in their payer networks, but they might also ask about other BOPs during their renewal. And that goes to this notion of if you're licensed in more than one state. Now, I want to distinguish, and I think this is a generally applicable concept to both the PBMs and the BOP realm, the difference between affirmative reporting obligations and more passive reporting obligations. And in the way I would distinguish those two is that an affirmative reporting obligation is one that arises once an event occurs. And so upon the occurrence of that event, it triggers a duty to report within a specified time period. I have up here an example from the Illinois Board of Pharmacy, and this says, failing to report within 60 days any adverse final action taken against a pharmacy, pharmacist, registered pharmacy technician, or registered certified pharmacy technician by another licensing jurisdiction in any other state, any governmental agency, any law enforcement agency, or any court for acts or conduct similar to acts or conduct that would constitute grounds for discipline as defined in this section. Now, that's a lot of words. It was tough to even read through that. But the reason why I did that is because one of the points I want to make here is that this is very broad conceptually. This is not a narrow in scope type of reporting obligation. This is purposefully defined very broadly to kind of capture this concept of other adverse actions or disciplinary action. What the board is really saying here is, if something's happened, we expect you to tell us about it. And in the state of Illinois, they expect it, if it falls within this definition or these parameters, to have that report made in 60 days. So this is an example of something I would describe as an affirmative reporting obligation. What I would describe as a more passive reporting obligation is that idea of when you're renewing your pharmacy license, or in the PBM realm, renewing your or re-credentialing with the PBM, being asked on that application. You're going to be asked for it, so then you need to handle it at that time. But also be aware of the fact that just like boards of pharmacy, PBMs may also have affirmative reporting obligations. Again, the idea of not just during the re-credentialing or the renewal process, but also potentially being asked to do this within a specified time period once an event occurs. I will also say, when in doubt, err on the side of caution. In my experience, you will not get in trouble. If you're asking yourself, do I need to report this? If you're asking the question, there's a good chance that you do, but when in doubt, it is better to report it. But to Harini's earlier point, control the narrative, frame the issue in the most positive way possible. Of course, we're not being misleading here. We're just trying to provide full context. But in my experience, you will not get in trouble for reporting something that you don't have to report, but you have the potential of running into issues if you don't disclose or report something that either the board or the PBM believes that you should have reported.
And Lucas, I know that we might save some of these questions for the end, but I just saw one that is relevant come through. What would you tell the Board of Pharmacy if your contract is terminated, but the PBM isn't telling you why you're terminated? So essentially, it seems that a pharmacy is being terminated without any stated reason from the PBM. In an instance of where you're being asked to disclose, say, actions by a payer, how would you otherwise suggest, or how would you otherwise, one, would you advise disclosing it in some instances, or two, how would you go about disclosing it?
Yeah, and this is a great question because we see this all the time. It's kind of like, I don't even know why I'm being terminated, so what the heck do I tell them without making this look more nefarious than it needs to be? And I think, again, it goes back to that idea. It's all about not just checking the yes or no box. It's about adding some additional context and controlling the narrative and framing the issues. So in this hypothetical, if you truly don't know why, one, my guess is that a pharmacy, depending upon the circumstances, may decide to challenge that termination. So if that's the case, that's number one. First of all, we don't agree with this and it's actively being challenged. The other thing is, and this really, I think, also creates an interesting dynamic. We're talking about the interplay between boards of pharmacy and PBMs. It also happens to be interplay directly between the public government sector and the private sector. And so one of the things that you can often say to a board of pharmacy is that this appears to be a misunderstanding. We're actively disputing this, but importantly, this is a private contractual matter and is not something that should be a cause for concern by the Board of Pharmacy. The pharmacy remains, always has been and remains in compliance with all of its duties and obligations as a licensed entity in the state of X. So that's one way to approach it.
That's great. And I'm just going to remind everyone of the disclaimer that we spoke about in the beginning, not to consider any of this as legal advice to be relied upon as we kind of go through this presentation.
Yeah, and with that, I often say we're presenting as attorneys, and I'm never going to be shy about that, and I don't think Harini will be either. We always recommend retaining legal counsel for these types of things. I have often found, and I say this all the time, if you've ever listened in on any of my Board of Pharmacy webinars, I say it, probably sounds a little old-fashioned, an ounce of prevention is worth a pound of cure. It is a lot easier to retain an attorney or a law firm to prevent an issue from ever arising in the first place than to have to come in and retain them to try and fix a problem that could have been prevented. So
I agree. And my saying is I would rather have pharmacy be proactive than be reactive. So same thing.
Yeah, same concept.
Mm-hmm.
Now, why is this all happening? Why are PBMs asking these questions? Why are boards of pharmacies asking these questions? One of the things that I've seen working with providers, and I completely understand the reason for this, is that sometimes it just feels like we can't win. No matter which way we turn, we're being asked all these questions. And guess what? If you're going to be courageous enough to own your own business, to run your own pharmacy, to become a pharmacist and all of those things, not everything is going to go perfect. I would tell you that I don't think boards of pharmacies expect that. I also don't think PBMs expect that. I think they recognize that in the process of running a business, in recognition of the fact that we're all imperfect human beings, mistakes will happen. But the notion here is transparency. And again, controlling the narrative. Why are they asking? The answer is because both boards of pharmacy and PBMs have duties and obligations to a much larger public, but they're also at the same time trying to kind of keep an eye on a large number of network pharmacies. Or in the case of a BOP, they're trying to watch over a large number of licensees in their state. So they need some broad, generally applicable mechanisms to kind of keep an eye on things. So for PBMs, this is one way to police and monitor the pharmacies that are admitted into their networks and doing business and dispensing prescriptions to the members in their networks. They want to make sure that they're keeping an eye on the providers in their network, that they're quality, reputable, qualified providers, but they also have reporting obligations at the federal and state level and also in the private sector to their clientele, which tend to be, generally speaking, plan sponsors. For boards of pharmacy, it's how they go about monitoring the pharmacies and pharmacists and pharmacy technicians licensed in their state. I will find, and I've often encouraged, for your home state board of pharmacy, at the bare minimum, get to know what your home state board of pharmacy's mission is. Almost every board of pharmacy will have a stated mission. Many people don't realize this, but I think if you look at that mission and you kind of say to yourself, well, how do I become kind of a player in achieving this mission as a licensee in my state? If you kind of reframe things that way, I think that's one step towards developing a positive relationship. We'll talk more about that later. But one overarching theme of a state board of pharmacy's mission is going to be this idea of protecting the public health, safety, and overall well-being of the residents in the state. So again, it's ensuring that only reputable, qualified providers are getting a license and maintaining a license to do business in their state as a pharmacy or a pharmacist. When we talk about the implications of providing responses to these questions, and again, this is going to be a recurring theme, but I want everyone to understand that just because you may have to answer yes to one of these questions, and in this example, yes would be the not preferred response, but have you been disciplined in the last 1 or 2 years or whatever the time period is, people don't want to have to say that. But I also don't want you to think that if you do have to answer yes, that it's game over. It is not. It's all about the transparency, and it's all about how you go about framing the issue and disclosing the issue. So there are implications, but I would say you are likely to navigate this successfully when you disclose this in an honest and accurate manner, but also frame it and control the narrative.
And so that brings us to a pharmacy's participation in a PBM network once they get past the credentialing hurdle of having to, for example, maybe proactively disclose any sort of past disciplinary actions. And so one of the most important things that pharmacies can do in the course of their participation, especially when it comes to audits and or investigations that are initiated by PBMs, is to appeal, and appeal. Can't emphasize that enough, and oftentimes pharmacies may choose not to appeal their audit results, just given the realistic administrative burden of having to dedicate separate resources of appealing those audit results while just keeping up with the day-to-day pharmacy operations. Or they might go through one round of appeal efforts and not consider further appealing them. Sometimes PBMs will suggest that final results are final and that there's no other additional recourse. But pharmacies do often have further administrative rights, appeal rights with some PBMs, for example, that allow for an additional appeals process after receiving final results by being presented to a review committee for further consideration. Or pharmacies may want to consider throughout the whole process of engaging with effective counsel to help them also engage in the process of disputing final audit results. And the reason that it's so important to dispute or appeal audits and investigations is because we have routinely seen PBMs expressly suggest that because a pharmacy didn't challenge the audit results, that they've accepted them as true, that they've accepted the discrepancies that the PBMs otherwise alleged as true, which may, again, not be the case, but perhaps because the pharmacy didn't expend the resources to appeal or the time to appeal, the PBMs automatically accepted them as the discrepancies to be true. And so for those reasons, I can't emphasize this enough. However minor, it's very important for pharmacies to resolve those discrepancies. And I like to say this is that for them to have the last word. Obviously, if PBMs may be very resistant in accepting some arguments or some documentation to resolve discrepancies. However, it's still very important for the pharmacy to be able to put their position, to be able to put their opinion as it relates to the discrepancies that were alleged in writing over to a PBM. And the reason is because PBMs may report pharmacies for any discrepancies that are identified during the course of an audit and or investigation. It's not necessarily, again, it's not necessarily always the case that they may report them, but it is certainly possible that for any discrepancies that are outstanding, that they report them. Again, this could be related to audits and investigations, but they could also report pharmacies for purely alleged contractual violations. For example, here we've included mailing. We've seen instances of where a PBM's reviewed pharmacies for their mailing practices, and in a particular state, that could be completely fine for a pharmacy that's in network as a licensed pharmacy to be able to mail prescriptions to its patients. However, the PBM might have a separate contractual violation if a pharmacy were to engage in that type of activity. Nevertheless, have PBMs reported pharmacies for mailing into their states to boards of pharmacies? Certainly. And so for that reason, it's very important for pharmacies to be aware of not just their contractual obligations with PBMs, but also, again, to be able to exercise any appeal rights whenever PBMs expresses any sort of discourse. And the concern with being reported to the BOP or to the Board of Pharmacy by a PBM is that however frivolous the issue may be, again, to the extent that it might just be contractual, or the PBM is maintaining their position in an audit, many states' boards of pharmacies have affirmative obligations to review any complaint that they receive from a PBM. And so for that reason, again, in a case of an audit or any sort of contractual dispute, it's very important for the pharmacy to continue their efforts to try to resolve that with the PBM, where, again, a PBM may consider filing a complaint against the pharmacy to the Board of Pharmacy.
And Harini, have you seen, I think you've already alluded to this, but have you seen instances where a PBM has made a report to a board of pharmacy, and during the process of the PBM's audit or investigation, now a separate board of pharmacy action has been instituted?
Several times. I would say that especially in the case of where we see the word investigation being thrown around by a lot of PBMs. Again, investigations can mirror audits. They could be the same documentation requirements that you see a PBM engage in or request during the course of an audit. But because they place a heightened standard on it by putting the word investigation in there, oftentimes, especially with discrepancies outstanding following an investigation, we see PBMs report pharmacies to regarding any of the outstanding discrepancies. This could mean issues related to prescriber authorization, member authorization, prior authorization, copay collection, again, and something as contractual as mailing. So it's very common for pharmacies to be reported over any outstanding discrepancy findings. And so while they're trying to work through their issues with the PBMs, they're also now having to face a separate board of pharmacy action over the same exact issue.
So kind of building off that, we had another question come in, and I'm going to slightly rephrase this, but do you recommend appealing or disputing even minor discrepancies that are alleged, even if there was no financial recoupment?
Yes, sometimes what we'll see is that there could be something as simple as a letter of warning. For example, if a PBM sees some outstanding discrepancies, may not subject them to any sort of recovery and issue a letter of warning or just, hey, a reminder. It's still very helpful for our pharmacy to, for example, if there were no discrepancies, to make it very clear that there were no discrepancies that even warranted a warning letter to begin with. And if there were any issues that they've otherwise addressed them internally, for example, with the corrective action plan or anything else, to be able to demonstrate compliance with the PBM. I say that not only for the purposes of maintaining a good relationship with the PBM, but also out of concern of being reported to a board of pharmacy, of course.
And hypothetically, if you were to put together those types of that type of correspondence, essentially kind of setting the record straight. Let's say it's on a minor issue that there was no financial recoupment, but lo and behold, it is reported to a board of pharmacy. Is there an ability of the pharmacy to perhaps use some of that correspondence as part of the board of pharmacy proceeding?
Certainly, yes. I think that those types of communications are, well, I'll say this, is that oftentimes when we see Board of Pharmacy complaints, or when you see Board of Pharmacy complaints, how common is it that you see a copy of the exact discrepancies or the report from the PBM just being simply attached to the complaint that they're making to the Board of Pharmacy? For that same reason, I don't see any reason why a pharmacy wouldn't be able to otherwise provide a copy of their communications with the PBM. Again, we'd have to work through confidentiality, of course, but taking that into consideration, why they wouldn't be able to demonstrate that they've otherwise resolved the issue or that there was no issue to begin with that warranted their reporting to the Board of Pharmacy.
Got it. And I just building off of one of Harini's points is I think, especially on this issue of whether you should challenge minor discrepancies, it goes back to that notion of an ounce of prevention being worth a pound of cure. I can't tell you how many times we've seen people take, essentially choose the path of least resistance because they feel like, well, it's only $1,000 discrepancy. Why would I spend $2,000 to solve $1,000 problem? The answer is, because one, it just very simply may not be $1,000 problem. It may look like it because the financial recoupment was $1,000, but if it jeopardizes your entire standing in the PBM network or with your board of pharmacy, you can see how it can exponentially become a much more serious issue.
That's right. And these things compound, right? You could get one warning letter. And one of the reasons that PBMs send this, even if there's no financial recovery, is also for paper trail purposes. And so for that reason, they could take that warning letter, they can combine it with an audit that happens perhaps down the line with another audit. And they could kind of paint this picture of a pharmacy to demonstrate non-compliance with their terms and conditions. And that could just certainly spiral into something such as network termination or a complaint to the Board of Pharmacy. And so moving on to some of the reporting obligations that pharmacies have when it comes to their participation in networks, we've addressed recredentialing or credentialing questions, some of those questions that we often see at the time of having to fill out those applications. But there's also additional reporting obligations throughout the course of the participation of a pharmacy based on the payers. So for example, if you were at some point in the course of your participation in a PBM network to face any sort of action from a board of pharmacy, that could require disclosure over to the Board of Pharmacy. I'm sorry, require disclosure over to the PBM. Again, the language and the requirements of disclosure vary based on payer. There's different time periods of which you need to make a disclosure within a certain time frame of. There's also different situations that require disclosure based on the payer as well. One payer may require disclosure to them, while another payer may not require disclosure. So we've pulled some sample PBM language here of a provider manual just to kind of go through it, and we'll kind of pick and choose some of these points here, but it is taken verbatim from the provider manual here. So for example, a PBM might require a pharmacy to notify the PBM in writing if the pharmacy's license permit is in jeopardy of being suspended or revoked, if the pharmacy receives any notice of proceedings which may lead to disciplinary action, any disciplinary action that is taken against the pharmacy provider or its personnel, including but not limited to action taken by a board of pharmacy, OIG, GSA law enforcement, or any other regulatory body. There's a subpoena records, or there's a seizure by law enforcement of the records, computer systems, financial records, accounts on real property. So oftentimes when we see pharmacies get noticed of a board of pharmacy action, or or in the course of a proceeding with a board of pharmacy action, or actually receive disciplinary action from a board of pharmacy, we often have to visit the PBM's provider manuals, such as this PBM's language, to determine if there's an express requirement to disclose to that PBM of any sort of action. So for example, just the notice of such action or a complaint may require disclosure. For example, the second bullet point says, whenever a pharmacy receives notice of any proceeding which may lead to disciplinary action. So here, there might not actually be any disciplinary action that's levied upon the pharmacy, but just the fact that there could be requires a pharmacy to make an express disclosure over to the PBM. Again, there's risks of being able to risks of disclosing this, and there's also benefits of disclosing these types of actions to PBMs. One of the benefits is maintaining transparency and suggesting that you're not concealing this information during the course of your participation in the network. One of the risks, of course, is especially when there's not actually been a proceeding yet, or there hasn't been disciplinary action, is again having to disclose this to a PBM when there's so many uncertainties around that. At the same time, does it let you control the narrative by making that disclosure? Certainly, yes, and that's very important. And so in this instance, just continuing that language, this pharmacy is required to provide notice to the PBM within 7 days of any of those issues having occurred. Again, that requires just notice of a proceeding, an actual disciplinary action, a subpoena records, etc. And oftentimes, pharmacies should be aware of these reporting obligations when they face any sort of board of pharmacy action. It's very important for pharmacies to review the provider manuals and their agreements to be able to understand what express obligations are on them during the course of their participation. And one of the reasons is because pharmacies that fail to disclose, or if a PBM identifies that a disclosure was required during any of this course of proceeding, that the PBM may decide to terminate the pharmacy, not based on the actual underlying action, but just based on the actual failure to report itself. And that's very important, is that yes, the action itself that led to the disciplinary action could have terminated the pharmacy from the PBM network. But what's more concerning is the fact that you failed to disclose it would be the sole basis of termination. And that is completely preventable in this circumstance.
So if we shift to some common interplay issues, and I think this is a good segue because one of the questions that came through while we were speaking was examples of possible Board of Pharmacy disciplinary actions. So we'll talk about that here with an example, and I'll give some others. But we see that very often boards of pharmacy have timing requirements as it relates to commencing operations after they're granted a pharmacy license. And so this is often not known by pharmacy operators. The idea is that when the day you get that license and it becomes an active license, the Board of Pharmacy expects that within a certain specified period of time, you're going to be up and running and doing meaningful business. The idea behind this is that boards of pharmacy want to know that when they grant licenses to pharmacies, that the pharmacy is capable of being able to service patients, so that if patients come to that pharmacy or perhaps rely on the Board of Pharmacy to find reputable providers, that they don't show up at a pharmacy that is not open and able to take care of their prescription medications. Obviously, you could see that having serious implications in an emergency situation. So in this case, talking about the interplay, one of the things that I often believe is overlooked by boards of pharmacy, and not for any nefarious reason, I think it's just commonly overlooked, is that to get credentialed in all of the major payer networks, it takes a lot of time. And there's times where we've seen a lot of delays, especially during COVID. We were seeing a lot of resources at the PBM level being committed to other areas for legitimate reasons, but that was also resulting in backlogs on the processing of applications and recredentialing. So the way you do business is by getting into the payer networks. But at the same time, the Board of Pharmacy, and we're going to talk about Texas. I'll tell you right now, spoiler alert, the time period to get up and running in the state of Texas is 6 months. So if on January 1st, you're granted that license to do business as a pharmacy in the state of Texas, they're going to expect that come the middle part of the summer that you're doing very real business. But at the same time, to be able to get credentialed, you have to have your pharmacy license. And so what happens if it takes more than 6 months for a PBM to review and approve your credentialing in their network? I'll tell you right now, it all comes down to communication with both entities. So in Texas, the Board of Pharmacy can discipline a licensee if the board finds that the licensee did not engage in or cease to engage in the business of pharmacy. They define these terms: operation of the pharmacy. Failure to engage in the business of pharmacy means the licensee did not begin operating the pharmacy within 6 months of the license being issued. This is really significant. And then we also say cease to engage in the business of pharmacy. So this is different. This means you started, but then you stopped. Cease to engage in the business of pharmacy means discontinuing operating the pharmacy for a period of 30 days or more, unless the pharmacy experiences a fire or a disaster, in which case the pharmacy must comply with section 291.3G of this title. So I put in parentheses relating to required notifications. By the way, I see this all the time. We ceased doing business because we had a serious natural disaster or whatever, a fire. So often I see pharmacy owners and pharmacists say, well, there's nothing I could have done. I had a fire. I wasn't doing anything wrong. And I'm like, I completely understand. The perception is that they'll understand, right? It was a mistake. We didn't do anything wrong. There's a good chance they're not, because they're going to say, You needed to notify us of this. So how is this notion of operating the pharmacy defined? In Texas, they define operating the pharmacy as meaning the pharmacy can demonstrate observable pharmacy business activity on a regular, routine basis, including a sufficient number of transactions of receiving, processing, or dispensing prescription drug orders or medication drug orders. So, what happens if you're not in any of the major payer networks and you just opened your pharmacy and you got your license? In the state of Texas, you better get open within 6 months. Except that if you can't, what do? You tell the Board of Pharmacy. They want you to communicate with them. And I'm telling you, I can't believe how receptive boards of pharmacy are to these types of communications. They just want to know what's going on. The worst thing you can do is just cross your fingers and hope they don't find out. The other thing that I see is it's been 6 months. This is going to get approved any day now, any day. And then before you know it, it's 9 months, it's a year. Then what do? The other thing I will say is I've seen cases where the pharmacy has been open, operational, has inventory on hand, is able in theory to dispense prescriptions, but is not in any of the PBM networks solely because of delay. They've applied, the applications are pending review. They're able to do a small number of cash-based prescriptions, something like that. In my experience, that small number of claims will not be sufficient to meet this definition. And so what that means is you got to communicate. You can't just cross your fingers and hope it all works out and that the BOP does not find out. You got to communicate with them. That is going to potentially save you in this instance. The other thing is communicate with the PBM. It's all about that interplay. Harini and I do this often. We can check in with the PBMs. You're allowed to do that. You could even say, I'm checking in because this is really becoming time sensitive and urgent. I filed my application on X date. I got my license on X date. I still haven't received approval. By the way, in my state, if I'm not open and operational by X date, I could get into trouble. Can you please prioritize my application or let me know what's going on? And then guess what? Then you can add that to your communication to the Board of Pharmacy. Dear Board of Pharmacy, I am writing to advise you that I am now 5 months into having my license. I'm concerned that I will not be able to be fully operational or, quote, operating the pharmacy, unquote, within the 6-month required time period. I want you to know that over the last several months, here's what I've done to try and address this problem. Based on the current situation, I expect that I will be open and operational by X date. Please confirm that this is acceptable. I will touch base with you to provide any further updates as soon as I have them. I'm doing everything I can. That type of communication is going to go a long way. It also just shows awareness, knowledge that you care, that you take this seriously. That is really big. And I think I kind of jumped ahead on my slide, but again, it's that idea of communication is key. I just can't emphasize it enough. And it's not just written correspondence, but you got to have the written correspondence because it's all about the paper trail, the documentation to be able to say that, hey, look, I notified you on X date. Here's a copy of this. I sent it via email to the pharmacy email address. But don't lose sight of simple phone calls, especially with boards of pharmacy. I have found that oftentimes those phone calls, if you're calling between 9 and 5, are picked up almost immediately because so few people use phones anymore. Everybody wants to email. So a lot of times a phone call can save you a ton of time. And every board of pharmacy has an easily accessible contact number to contact their kind of general help desk. And when I call them, they almost always either A, will know the answer to the question, or if they don't, you can almost hear them scrambling to be like, hold on, let me see who would be best to answer that question. So they are there to help and they want to help.
And I think that, Lucas, you've mentioned communication is key, and to that end, I'd say transparency is key. They kind of go hand in hand. Not only are pharmacies, I'd say, legally obligated to be transparent, especially when disclosing anything to the Board of Pharmacy or to the PBMs, it's just very helpful, I'd say, that pharmacies who are transparent in making communications or disclosing any sort of actions to either a board of pharmacy or to a PBM are often in a better position than those who fail to disclose or be proactive in any of their communications. And to your point is that most times boards of pharmacies and PBMs could be reasonable, and there are certainly some instances in which they give consideration, especially when a pharmacy is being transparent. And the most problematic issues, and this is me saying this off the slide exactly, are those that appear to be concealed. If being expressly asked if there's any sort of ongoing actions or past actions, and if a pharmacy is saying no, that is often usually the case of further action from either a board or from a PBM. The failure to disclose is often one of the most harming things that a pharmacy could do to itself.
And I can't emphasize that enough. Anytime you set up that perception of concealment, those are the hardest ones to overcome, because I've litigated these cases, and the cases that tend to have the most successful results are either one where we can say with 100% accuracy and certainty, we told you about this, we disclosed this, we were never trying to hide this from you, this is not a terminable offense, we're doing the right thing and you're punishing us for that. Those cases tend to resolve on very favorable terms. And again, it's all about that idea of transparency. I do want to real quick make sure that I answer. Can't thank you enough for all the questions, because we've been getting a lot of very good ones. So I do just want to go back real quick to the examples of common BOP disciplinary actions. I gave that one about failure to operate within a 6-month period. That's specific to the state of Texas. Most states have some variation on that, but again, not legal advice. You need to make sure that you know your state specific rules and requirements. To the extent that you want assistance with that, we're here to assist even on simple questions like that. We try to be practical with all of our clients about that stuff. Another really good example, and again, this ties right into what we're dealing with. The most common thing I see is failure to disclose or report changes. This isn't just disciplinary action. I want to talk about very simple stuff too. It could be a substantial change in your hours. It could be change of pharmacist in charge. This is a really big one. Not updating the board of pharmacy records to say, hey, we hired on a new pharmacist in charge. They want to know who's running the pharmacy. Another one is having a time period without a pharmacist in charge. That's big. And then we also, Harini, were you going to say something? I didn't want to cut you off.
No, I just said, and I thought you were going to say access to a pharmacy, meaning, improper access by any individual not associated with the pharmacy, accessing the pharmacy.
Yeah. Another one is a change of location. And again, for some of you, you may hear this and go, well, of course I'm going to tell the board of pharmacy if I change my location. Sometimes these things get lost in the shuffle. So I go back to, when in doubt, report it. You will not get in trouble for reporting something that you don't have to report. No one's going to scold you and say, why are you telling us this? And in fact, if they do, I've had times where a board of pharmacy has responded, thank you, Mr. Morgan, we appreciate the update. They're not going to say, why are you bothering us with this information? Because technically you don't have to report it. That does not happen.
That said, we did just get a question come through about whether or not appealed audits with any outstanding denials or chargebacks should be reported to the board of pharmacy. Again, to the extent that it doesn't fall into that question of where there's been any sort of action against the pharmacy, more so disciplinary, usually consisting of a termination from a PBM network, that might not require disclosure to a board of pharmacy. That's when you would check to see what is required to be disclosed. I'd say something as much of as our audit chargeback doesn't necessarily need to be disclosed, but certainly something that we want to look at based on a state-to-state basis. At the same time, does that mean you shouldn't appeal it further with your PBM? No, you should certainly do that.
And we also had a question about retaliation, and I do want to hit this one because I think it's really important. This is probably one of the most commonly asked questions that Harini and I get. And it's essentially, is it typical for PBMs to retaliate against a pharmacy if they hire attorneys and fight back? The answer is no. And it may sound like, really, Lucas, but there's a reason for that. It is prohibited by law. Medicare explicitly prohibits retaliation against pharmacy providers for exercising their rights under the law and their contracts, whether it, prompt pay, those types of things. You are expressly permitted to fight back and invoke those rights. Most states have corollaries to the Medicare rules and regulations prohibiting retaliation. And the other thing is, this is why I go back to recommending that when in doubt, retain legal counsel or at least get a legal opinion, because there's a method to this where it's done in a professional manner and it's done in an appropriate manner. So there's a way to do this. And that goes back to this idea that at times it can be an adversarial relationship, but it's done professionally. And so in our experience, we do not see retaliation. To the extent that there are protections against it, and there are remedies for that type of behavior. But I would say it's not common, and it's also absolutely the exception to the extent that it exists. So just a final note, because I realize we're coming up on 2 o'clock, at least Eastern Standard Time. Fostering the relationship with BOPs and PBMs, can't say it enough. Transparency, communication, ways to get familiar with your BOP. Start calling them when you have questions, even simple ones. Attend a Board of Pharmacy meeting. They are usually public proceedings, if not always public proceedings you can attend. I recommend that your first time attending a Board of Pharmacy meeting not be because you're on the agenda. Do it as just a kind of fly on the wall. Get to know who's on your Board of Pharmacy. Call them, email them. Don't be a stranger necessarily. With PBMs, figure out who at a PBM you can contact. I'm going to tell you right now, it may be general information. It might be pharmacyhelpdesk.com kind of thing, but figure that stuff out. Interact with them. Worst case scenario, you try and it fails, but at least you can say as part of your documentation that you tried to reach out to address an issue. So I will end kind of the formal aspect of this interplay between, or the ABCs of BOPs and PBMs, with kind of a quick transition with just kind of one public service announcement. And this ties directly into some of the concepts we're talking about. Just kind of one current event update that's particularly applicable to pharmacies and independent providers in the state of New York. But I also say, even if you're outside of the state of New York, you should be aware of what other states are doing to kind of regulate the industry, regulate the marketplace, and specifically the relationship between pharmacy benefit managers and pharmacies. So just this past week, the state of New York, through its Department of Financial Services, and then within that department, its Pharmacy Benefits Bureau, introduced 2 things. One is a request for comments and data regarding PBM marketplace conduct. And there is a deadline for for any interested stakeholder to participate in this, and it's May 1st. If you want to participate, you can contact Frier Levitt. We will assist you. We've done this on multiple occasions. We know what we're doing. We know who we're talking to. So if you want to participate, reach out to us. If you're not familiar with this, call me just to learn more about it. Just a brief overview of what they're talking about. Use of drug manufacturer rebates, limits on mid-year formulary changes, minimum network adequacy requirements. This is really big. Within this topic, it's going to be the concept of closed networks, the ability of pharmacies to be kept out of certain PBM networks. Also, they are seeking information about aberrant quantity and product list restrictions on pharmacies, your ability to dispense certain products, or being told you can't dispense products at all, or putting limitations on the dispensing of certain products. They are asking about it. They want to hear from you. So it is an opportunity to be directly involved. And then the next thing, this actually has the more immediate deadline. I'm holding them up right here, but this is a draft set of rules and regulations. It's 15 pages long, and this is being considered to be implemented in the state of New York. It goes directly to pharmacy benefit managers. What I will tell you right now is if these were adopted as written, there's going to be a lot of upset independent pharmacy providers. So you need to have a say in this stuff. I will leave it at that. The deadline to comment on this is this Friday. They only gave 10 days to comment on it. So if you're just hearing about it now, it's because there was only 10 days anyway. So thank you all for your time. Really appreciate your participation.
Thanks, everyone. Lucas, if you want to go to the last slide, just so that everyone who just joined us has our contact information. Again, I know we didn't get to every single question in the Q&A chat, but if you have any questions, feel free to reach out to myself or Lucas. Also, feel free to email either one of us if you want to be added to our just our mailing list to, again, receive updates that we send out on a regular basis, our newsletter, or participate in any other future webinars that we might hold going forward. So thanks, everyone.